Mathew Jagger was charged and convicted with attempted second-degree rape of a child. He is appealing his conviction, arguing the state's evidence was insufficient and that his intent was not proven under the substantial step standard. The substantial step is conduct that strongly indicates a criminal intent to commit the crime, more than just preparation. Let's take a look at the arguments.
Would you like to reserve time?
Yes, I would like to reserve 3 minutes, please.
All right.
Good morning. My name is Beverly Tsai with the Washington Appellate Project, here on behalf of Mr. Jagger. A police officer was pretending to be someone else when he texted Mr. Jagger saying, quote, "Let's meet up and see if we connect," end quote. That was the extent of the plan when Mr. Jagger went to the mall to finally see a person who Mr. Jagger was not sure was real, a person who would not show him ID, would not send him pictures when he requested them, and who declined many requests to talk on the phone or have video chats. The state failed to present sufficient evidence for the crime of attempted second-degree rape of a child, and for this and the other reasons discussed in the briefs, we would ask this court to reverse. To prove attempt, the state must prove requisite intent and a substantial step.
Can I stop you there? One of the cases you relied on was a case called versus Grundy.
Yes.
And one of the things I noticed about State versus Grundy is it did not use the model penal code substantial step test that you just articulated, but used, I think, the older overt act test. Does that matter?
I don't think it matters. I think an overt act would require more than a substantial step. And in Grundy, where the defendant had been negotiating with a police officer who was undercover for a drug exchange, they agreed on the price, but he wanted to see the drugs first. I think that's similar to what happened in this case where Mr. Jagger had been conversing with somebody online and they wanted to meet first.
If overt act would require more, in your words, than substantial step, wouldn't that imply it's a higher standard for establishing attempt than is currently the law?
Yes, I think still under the substantial step test, mere preparation is not enough. I think in this case, with Mr. Jagger, I think their plan to meet first and see what happens there at this stage, they were still in their meeting phase. I think that is preparation under the substantial step test.
So if I could be clear as to your argument, you're agreeing that overt act probably is more than substantial step, but you're saying it doesn't make a difference in the analysis of Mr. Jagger's case.
No, I don't think it does make a difference in this case. Mere preparation is not enough. In this case, Mr. Jagger was skeptical about who he was speaking with. He said he was not sure if she was real, asked for a picture of her state ID, asked for a new picture of her holding something with his name.
He showed up at the Kohl's parking lot with condoms to meet her.
There was a lot of items in his car. He lived in it periodically. He was sleeping in the car the night before he drove to the mall.
This is the sufficiency of the evidence argument. So we view it in a light most favorable to the state, right? So he showed up at the parking lot with the condoms to meet her. Why isn't that more than preparation? Why isn't that a substantial step?
I think in the context of that they had planned to meet at the mall, they did not have a specific plan to have engaged in any sex acts at that time. The plan was to meet first. He wanted to meet in an even more public place. He suggested meeting at the Starbucks, which is in the center of the mall. It's different than in the cases where a defendant agrees to meet someone at a hotel room or gets a room. They weren't planning to meet at his car. They were planning to meet in a public place, and that was their initial meeting. So
Plan was to have sex in the van.
I'm sorry?
The plan was to have sex in the van. Isn't that clear from the communication?
I think still as what the police officer had said to Mr. Jagger saying, "Let's meet up and see if we connect." I think it was still the plan to have the initial meeting and then potentially go from there. They had talked potentially about getting a hotel room, about potentially going to another place, but there was no specific plan to.
Well, it seems like it was more than a potential. At one point, there's an explicit proposition for sex, and the response is, "I would like to do that." I remember because it was misspelled, WLD. WULD. I mean, and that was some days removed from the meeting that did occur. And I would agree with your characterization of the later conversation, but doesn't that simply go to weight?
I think that those exchanges is still in the context of we're going to meet first, and then maybe these are things that we would be interested in pursuing after that. But going to Kohl's to meet her in a public place in the store, which is what they agreed on, I think that is still the meeting phase. I don't think that is enough for a substantial step. I also wanted to make sure that I discussed the Batson issue. The only issue in this case is whether, in light of all of the evidence, there was evidence of purposeful discrimination. And that's a very high showing for purposeful discrimination. And I don't think that is met here, where the panel was majority women. There were 35 women, 28 men in the panel. There were 8 women and 6 men in the jury box when Mr. Jagger moved to strike juror number 17.
Why wouldn't this be harmless error? Is it prejudicial to have a qualified juror serve?
I think the prejudice is demonstrated by the juror's answers to the questions and her lack of thoughtfulness about bias and how that influences her decision making. It's different than in State v. Hale, where the juror had some work experience that involved
what answers of juror number 17 do you say show lack of thoughtfulness?
I don't have the record right in front of me, but the way that defense counsel characterized it was they believed these were vanilla answers, standard law and order kind of law enforcement answers.
I mean, at one point she was asked something along the lines of, will you follow the law or something? And she said, it was a yes or no. And she said, yes. What's not thoughtful about that?
I think there's no basis to strike her for cause. If she answered that question differently, I think there would be a basis to strike for cause. But in this case, that is so fact intensive, it's an attempt crime, an incomplete crime where the deliberations are focused on the defendant's state of mind and require such a nuanced assessment.
Having trouble with it, there's no basis to strike her for cause, so there's no actual bias. Then she's otherwise a qualified juror. So it brings me back to my other question. Where is the prejudice in a qualified juror sitting on the jury?
And I know that I'm sorry if I may just wrap up the answer really quickly.
Go ahead.
As this court has acknowledged, it's a difficult thing to prove, but I think because of the nature of her answers and how they demonstrated a lack of thoughtfulness about deliberations and bias, I think that undercuts her ability to weigh the evidence in this case.
So if I may just follow up, is your argument premised on this lack of thoughtfulness alone, or is it also premised on a viewpoint that juror 17 was wealthy?
I think that is also part of it. Again, it's a very fact-intensive case. This is also a case involving a poor person who lives in his car, and that a person who comes from more wealth and privilege might not understand a person who lives in their car, keeps a number of belongings in their car, such as Mr. Jagger.
Okay, you'll have 2 minutes for
Right, thank you.
Good morning. May it please the court. My name is Ed Stemler from Snohomish County Prosecutor's Office. I represent the state of Washington, the respondent in this case. We're asking that you affirm the defendant's conviction. Sufficient evidence did support the conviction. As the court has previously pointed out, the standard of review here is very favorable to the state. And I would, if you have any questions about that at all, I would refer you to RP 468 to 470, where at that time, the arrangements had already been made for him to meet who we believed Sarah to be a 13-year-old girl at the Kohl's parking lot. And he had asked, what do you want to do after? She asked, what do you want to do after Kohl's? And the answer was everything we want to do with each other. And then after that, he says, do you want to have sex with me in the back of the van? So clearly his intent when he shows up at the Kohl's parking lot in his van with condoms there to meet this 13-year-old girl, he had taken a substantial step, and the trial court was correct in its analysis of that. But this court's review would also bear that out. Exhibit 14 was transferred to this court as well. And those specific texts you can find at page 188 and 189. So there's really not a question about whether sufficient evidence supports this conviction. With regard to the Batson issue, the standard of review there is clearly erroneous. So the trial court is in the best position to view what's going on during this jury selection process.
When I read your brief, it did not appear that you made a particularly robust defense of the Batson ruling.
Part of that's fair enough.
Okay.
And the reason for that is because, as Judge Bowman pointed out, even if there was error, it's harmless in this case because it just results in
so let's take that in pieces. So even if there was error, has the state effectively conceded that there was error here?
No.
Okay. On the issue of prejudice, what I want you to assume is that there's something valid about defense counsel's view that somebody who is wealthy, as juror 17 appeared to be, is not a good juror for somebody who lives out of their van and stores their belongings there, which in this case includes condoms. That juror was then allowed to be in the jury. So why would there not be prejudice there?
For the same reasons in State versus Booth from Division 1, State versus Hillman from Division 3, and State versus Hale in Division 2, the result is, and counsel conceded here, that there was no actual bias. There's no basis for a for-cause challenge. So the result is seating a juror who is qualified, who participated in a constitutionally valid verdict. And so there is no basis for reversal in that. They can't show prejudice by if some other juror was on there, or if this juror wasn't on there, the result would have been different under the non-constitutional error standard.
How would one go about showing that had juror 17 been stricken, the result would have been different?
I think those 3 court cases that I previously mentioned acknowledge that's a very difficult standard to meet in any case, because again, you're seating a qualified juror who's participating with 11 other jurors. So it makes sense in that context. And there is no constitutional right to a peremptory challenge. That's been emphasized by the courts a number of times. And so under those circumstances, even if the court did err, and again, the state is not conceding that, the defense didn't go through why she excused all the other female jurors that were excused, and it wasn't, so the court is sitting there listening to this and understood what the defense counsel said, that this person gave vanilla answers and that, her socioeconomic status might be different than the defendant's, but the court still came to the conclusion that that was not allowed.
From the transcript, it seemed that what the court was basing its decision on was a pattern. And at the time, the information about the pattern was incorrect. And it turns out that the strikes that had occurred were 3 women and 2 men. Isn't it kind of dangerous precedent to indicate that if you strike a 4th person of the same gender, that's a prima facie showing of discrimination?
I think it's a very fact-intensive inquiry that the court has focused on, because in State versus Brown that I cite in my brief, the state struck 6 women, and those were found to be valid strikes for other reasons. It wasn't based on gender. And so I think it's just a very fact-intensive inquiry in each case. I don't think we would be able to come back before you and say, well, there was 3 jurors who got excused in this case, therefore excusing a 4th woman automatically means bias. That's not the case. So you have to go through a variety of factors in looking through that.
But what more existed here other than the fact that this was, at the time, a perceived 4th challenge to a woman?
And again, I can only rely on the record what the prosecutor and the court were talking about at that point, which it appeared to be a pattern of excusing female jurors. And by the time they got to that 6th peremptory challenge, the prosecutor raised it and the court agreed.
Well, that perception later shown to be a misperception is what caused the court to go to the next step in Batson. Right? It caused the court to inquire further. And then the further inquiry was to ask for a gender-neutral explanation. And it struck me that the trial court judge thought that explanation then was evidence of pretext. So would we look at the prima facie showing once there's been an inquiry and a ruling, or would we look at the totality of the circumstances that supported the ruling?
My understanding of the record in this case, and pitted against State versus Brown, that says if the party offers an explanation for that, you kind of skip over the prima facie showing. And that's what happened here, I believe, is that the defense counsel offered a gender neutral reason for exercising the strike. And so at that point, we're on to the second step. And Brown says, once that happens, you're kind of past that first step. And so the court did not accept the gender neutral explanation given by defense counsel in this case. And so again, using the clearly erroneous standard, I think a lot of deference has to be given to the trial court under that circumstance. But again, pointing out in my brief, I didn't go into all the details of this because underlying it all is the harmless error standard that's virtually impossible under these circumstances for the defendant to meet. One other issue I did want to address, I couldn't find any cases right on point that state the rule that the state is asking you to apply in this case with regard to the Miranda ruling. The court held a Miranda hearing. The state believes the decision of the trial court was correct and it was supported by substantial evidence. It was credibility determinations based on their expert. But what I'm asking you to adopt is the same rule in the Eighth Circuit and the Ninth Circuit that I've cited in my brief. And that is when a court finds statements admissible under Miranda, but those statements are not admitted at trial, the appellate court need not consider whether the statements were admissible. I'd ask you for a rule just that straightforward, because I couldn't find anything in Washington in my research.
Your theory there is even if statements are suppressed because they're a violation of Miranda, so long as they're not coerced, they can still be used for impeachment.
Yes.
And so this person was left in no worse shape than had he been successful in his hearing, because he still would have had to testify consistent with his statements. Otherwise, they would have been admissible for impeachment.
Exactly, Your Honor. Exactly. And the court's finding.
Isn't the difference whether they would have been admissible as substantive evidence?
Yes, whether they would be admissible in the state's case in chief as substantive evidence versus impeaching the defendant's credibility.
And there would be a limiting instruction about how the jury could use them.
There very well could be. I mean, yes, if it was requested, it would be given most likely about how it is to be used in that circumstance. So
it's still kind of it's evidence the jury never had. It's difficult to see how it affected the proceedings.
Exactly. And so it'd be nice if there was something just that straightforward that says there's no basis to appeal if those statements aren't admitted at trial. And so that's what the state is asking for in this case. So overall, there was no prejudice from any of these issues, and the state is asking you to affirm the defendant's convictions. Thank you.
Thank you.
I wanted to start with Judge Bowman, what you were asking about with the Batson issue, the prima facie showing in this case. I think that is a problem in this case where we wouldn't get to the other questions if there was no prima facie showing. And I think the state is talking about reviewing all of the fact-specific inquiry and reviewing the totality of the circumstances. And that's about the third step about whether there was purposeful discrimination. So I think that those are two different steps in the analysis. And I think in Hillman and Booth, none of those cases stand for the rule that a person can never show prejudice for an erroneous Batson ruling. It's just and those cases are different.
That would be incorrect, right? A person, I mean, we see cases from time to time in which we have declarations from jurors that don't adhere in the verdict about what went on, bias that maybe wasn't evident to everyone at the time of jury selection, but then emerged during deliberations and is evidenced. So there's a difference between those. I don't see that those cases would have to say you can't show prejudice if there's not a record from which we could get to prejudice here.
I think still so for example, in Hillman, there was no error in denying the peremptory strike. There was no erroneous ruling there. So I think that case is not controlling here. In Booth, the defendant had no argument regarding prejudice. And the facts in this case are different than the facts in Hale. And the reasons that counsel wanted to strike the potential juror in this case and the potential juror in Hale are different, and they have different effects on the outcome at trial. So we would ask the state to reverse and vacate, and in the alternative for the issues raised in the brief to reverse for a new trial. Thank you.
Thank you very much.
Following these arguments, the court affirmed Mr. Jagger's conviction, deciding the intent met the substantial step standard. Do you disagree with any of the arguments heard in this appeal? Let me know in the comments below, and please subscribe for a new appeal video every week. Until next time.